Let's talk about when your spouse might be required to pay your attorney's fees. This is a question that comes up quite commonly, and it is an area of law that we have handled hundreds of times here at the McConnell Family Law Group. There are two primary ways to get your spouse to pay your lawyer's fees. One, your spouse agrees to pay your attorney's fees, or two, the court orders your spouse or your ex-spouse to pay for your lawyer. With regard to the first, your spouse agreeing to pay, this is more common than you might expect. And I'm talking to both the prospective payor and payee. That is, particularly in divorce cases, if one spouse controls the family finances and hires an attorney, in many, even most cases, that spouse's attorney will strongly encourage them to use family money or credit to even the playing field so that the other spouse can also have an attorney. Attorneys in this practice area do this as a matter of courtesy, but also because we know that ultimately a court will most likely require it. The second area is mostly self-explanatory. You or your spouse petitions the court for access to attorney's fees, and the court approves the request. This is very common in divorce cases, but less common in post-judgment litigation. There are three areas of family law where attorney's fees are most commonly in play. One, in a divorce action, the court may order one spouse to pay the attorney's fees of the other if that spouse has substantially more financial ability than the other spouse. Two, in a custody case, the court may order one parent to pay the attorney's fees of the other if that parent has substantially more financial ability than the other parent. And three, in a motion for contempt matter or a motion for sanctions, the court is punishing somebody because they haven't followed existing court orders or they otherwise cross the line in what the courts consider to be acceptable litigation. That punishment can include paying for attorney's fees. What about the amount of attorney's fees? The court has the authority to order your spouse to pay for reasonable attorney's fees. Absent agreement, judges are required to look at the services provided, the value of those services, the scope and the complexity of the case, the time required, as well as the skill and labor expended by the attorney. The attorney's hourly rate may be compared to other comparable attorneys in the area. It is important to note that our firm, and many others, do not take the risk that the court will eventually order the opposing party to pay your attorney's fees. We do take it into account with regard to the level of the retainer we quote, but in all events, we do require all clients to have money in trust for us to work on their matter. We can discuss possible strategies for you if you feel like you do not have access to money. You may be surprised what you can accomplish. This area of the law is confusing and very fact-specific. If you have any questions about whether your spouse might be required to pay your attorney's fees, give us a call. We'll be happy to talk to you about the underlying claims that you may have and whether or not it's possible that your spouse could be ordered to pay your attorney's fees. Find peace through strength.